May it please the court and opposing counsel. Good afternoon, Your Honors. My name is Flor Diaz-Waite, and I represent the appellant, Mr. Florence. I'm requesting 4 minutes for my rebuttal. Your Honors have set this oral argument in this case today. The state has filed supplemental authority, which I imagine we want to discuss, citing Baxter v. State out of the 5th District, Unless the court wants me to address this supplemental authority first, I'd like to highlight some of the facts of our case, of Mr. Florence's case, that I think this court should consider in making its decision. Would the court like me to go ahead and discuss?
It's your argument, go ahead.
Sir?
It's your argument, go ahead.
Thank you, Your Honor. So, Your Honor, from the defense's perspective, on behalf of Mr. Florence, the lower court erred in denying Mr. Florence's motion to suppress because the state did not present sufficient, competent, substantial evidence that officers had the necessary probable cause.
Ms. Diaz-Waite, will you pull the microphone just a little closer to yourself?
Of course. Yes, sir. Is this better?
Yeah, that's better.
Thank you, Your Honor. So Mr. Florence had a reasonable expectation of privacy in his vehicle, in particular where that vehicle was parked, which was lawfully and in front of an apartment building where he was living. Officers in this case had no evidence or reason to believe that Mr. Florence was engaged in criminal activity when he walked to his legally parked car and got in it.
Well, that was a consensual encounter when the officer knocked on the window, right?
I would agree, Your Honor, yes. And only seconds transpired before Mr. Florence was asked or removed from his vehicle and did so. And I think the state would agree that this case is one where the sole basis for the warrantless search of Mr. Florence's person and his vehicle was the odor of cannabis.
Is that really the sole basis? I mean, the body cam video was entered into evidence, was it not?
It was, Your Honor.
All right, and the officer approached the car and remarked how dark the tint on the windows was, did he not?
He did remark that.
Right, and then after smelling, or the officer saying that he smelled marijuana, I believe the officers, I've listened to the video a couple times, asked the defendant twice to put the vehicle into park, and then the defendant complied with that, so that the vehicle was running, the lights were on, and he had to put it into park, correct?
I'm not sure if I agree with Your Honor that he had to put the vehicle into park. I do agree that there was something in the audio with respect to parking the car.
Well, was there something in the audio twice where he was commanded twice to put it into, and then the defendant made a movement, right? So the question is whether it was hemp or marijuana, right? Was he operating a motor vehicle or able to operate a motor vehicle within the meaning of 316.193?
And I think that's an interesting question, Judge. I think he was certainly in actual physical control, as we might be concerned in a driving under the influence case otherwise.
So was he charged with DUI?
No, Your Honor.
Is there anything in the record that would lead us to believe that Sergeant Pandak did a DUI investigation after he was arrested?
No, Your Honor.
No field tests, nothing like that?
No, Your Honor. And I would actually argue that there was affirmative evidence of his sobriety.
When was Mr. Florence seized, do you think?
I think the moment that the officer knocked on his window and the officers were surrounding his vehicle, that he wouldn't have felt.
So knocking on the window was the seizure?
I don't think he would have felt.
Or telling him he couldn't leave? Was that the seizure, or telling him to put his car in park? That seems like a seizure.
Certainly.
Okay.
But you just said, I thought, that knocking on the window was a consensual encounter.
Well, Judge, I think talking to an officer is a consensual encounter. I think also with Your Honor bringing up the issue of whether or not the vehicle was in park is another potential wrinkle.
Well, that goes to the idea of whether there are additional circumstances supporting probable cause, and in the sense of once the officer smells marijuana and the car's in drive, and he was told to put it in park, then can we on that basis affirm holding that, well, there were multiple indicia of probable cause, that is, the smell, and he was getting ready to drive. He could have been driving under the influence. But aside from that, I'm not asking you to concede that, of course, but knocking on the car window, that's not a seizure, is it?
I don't think the action of knocking on a window and someone acquiescing to rolling it down is necessarily a seizure, but I will highlight to the court again that there were multiple officers present. They were kind of surrounding the car at that point. It wasn't just Sergeant Pendak that was standing outside. Additionally, Judge, there's a difference in this case than many of the other cases that we have to consider, including Baxter, including Owens, where whether or not Mr. Florence was engaging the vehicle in park, he was parked directly outside of his residence. The officers saw him walk from his building to his car. They did not note that he was stumbling. They did not note that he had any issues
Right,
walking to the car.
there's no evidence of any circumstances like that.
No, there aren't.
I don't think anybody would disagree with that.
Okay.
But back, aside from the possibility that there are other indicia of probable cause, assuming there are not, and that the case is based on the fact that he rolls his window down in a consensual encounter, the officer says, hey, roll your window down. He does. Immediately, the smell of marijuana wafts out of the car.
If I may, Your Honor, I would respectfully disagree that that's how it was described in the testimony. The sergeant did not testify that there was an immediate waft coming out of the vehicle, and that's something I want to highlight to
Well, he
this
said
court.
he smelled marijuana.
He did
As
say
soon
that
as
he
the window
smelled
was-
that.
As soon as the window was rolled down. I mean, the smell of marijuana is very strong.
Your Honor, respectfully, he did not say that he smelled it as soon as the window was rolled down. And I would actually like to highlight to the court the additional evidence that was presented at that motion to suppress hearing, indicating, unlike the other cases that the court has to consider, including Baxter, including Owens, in this case, there was evidence that there were other people smoking marijuana at that complex. There was evidence that there was it was from the testimony of Ms. Stephanie Jones, who testified at the motion to suppress hearing, that not only did someone come and knock on her door to alert her that Mr. Florence was being arrested, that person had a marijuana cigarette tucked behind their ear. So unlike the other cases, I think a huge distinguishing factor in this case is that Ms. Jones testified uncontroverted
Didn't the trial judge find, as a matter
testimony.
of fact, that the other people smoking in the area was not the basis for the seizure, was not what Sergeant Pandak smelled?
I'm sorry, Judge, can you repeat the question?
Didn't the judge, in his order on motions to suppress, specifically find that the testimony about the other people smoking was not really credible and he didn't follow it?
I disagree, Your Honor. He did not make a credibility determination.
Was there testimony that how close those people were to the vehicle at the time, and what time there it was, and even if it was possible that it was someone else, under the kind of practical and commonsensical standard of probable cause, and we've said that in Jordan, the Supreme Court has said it in Glover, isn't that enough for the officer to make further inquiry?
Maybe in a different case. In this situation, the officers knew that he wasn't smoking. He wasn't smoking while he was walking to his vehicle. They had seen him 15 minutes prior. There's no concern with his sobriety when he's getting to that car. We know that he wasn't smoking when they knocked on the window and he rolled it down. There wasn't any testimony about
I
smoke
think
coming out of the
I
car.
think your argument is not that persuasive, just speaking for myself. I think your argument here is that the smell of marijuana that the officer testified, I read the transcript, I watched the video, I read the court order. I don't think there's any just speaking for myself, I don't think that is your best argument that, well, the smell of marijuana could have come from somewhere else. The officer testified, the window rolled down, and he said, "Can I go?" And he said no, because he smelled marijuana. But your argument, I think, is that alone, under Baxter analysis, if you wish to rely on that, is not enough.
That's
Are you
right.
going to make that argument?
I don't think it's enough, Judge. I think
So
that
tell us why the smell of marijuana alone is.
So let's get
excuse
back
me.
to what the officer said. Go ahead, Judge, I didn't mean to
Yeah,
interrupt.
that's okay. Tell us why the smell of marijuana alone is not probable cause.
in this specific case,
Period.
under these
As-
facts,
As a rule of law.
well, as a rule of law,
He's
obviously
asking
the
you a
courts
friendly
have
question.
said.
He's trying to get you someplace that might help you.
I can understand that, but I'm just focusing back on the facts of my case to support the analysis that the court is doing here. Again, in this specific situation, to say that there was competent substantial evidence that there was a credibility determination made by the court as with respect to the smell doesn't comport with what the evidence was. That's not what was presented as testimony.
Well, let's just go there. Let's go to the testimony. The officer testified, "I smelled marijuana."
Correct.
And the argument made to the trial court is the smell of marijuana and the smell of hemp, which is legal under federal and state law, are indistinguishable. The challenge here in this record is there is no testimony or no evidence to that fact. There's argument by counsel But there's no evidence that these smells are indistinguishable, and all you have is Officer Pendak saying, "I smelled marijuana." Was there any evidence to refute that in the this record, or to call it into question before this trial court judge who had to make the ruling on the motion to suppress?
I'm not sure that there was, Judge. I would also point the court to the fact that the officers didn't ask about hemp. They only asked about a medical marijuana card. So they
But that's your defense. I mean, you've raised the defense, and the trial court heard argument, but no testimony on whether these two odors could be distinguished or not. We don't know that. We can't test that from the record either. So what is this? And I think that's different than what you saw in Baxter and some of the other cases. So even if this court were to get to the smell of marijuana versus smell of hemp case or question, is there enough evidence in the record to reach that question?
I'm not sure I understand Your Honor's question. So are you saying that because there wasn't additional evidence of hemp versus marijuana in the record that the court can't make a determination on that issue, or?
Right. There's no evidence on hemp. There's argument about hemp, but there's no evidence as to hemp. The only evidence we have is the testimony from the officer that he smelled marijuana.
And I would respectfully push back that, is that competent substantial evidence at this point, knowing that hemp and cannabis do smell identical?
You're saying knowing. How is a court to know that? Through argument or through evidence?
I think probably the best thing would be evidence. I think I would also ask the court to consider, the many other cases that have had this type of testimony presented.
So we take judicial notice.
I hope that we get there, yes, Judge.
Okay.
I think to police officers.
To get back to the issue of the lingering marijuana in the area versus what Sergeant Pendak smelled, the trial judge in paragraph 3, the last two sentences, this court does not believe that the odor of cannabis Sergeant Pendak smelled was the result of the lingering odor of cannabis in the area. Sergeant Pendak specifically recalls that he detected the odor upon the defendant bringing his vehicle's windows down.
Right, and I would respectfully disagree, Your Honor, again, pointing to the testimony that's in the transcript. That is not how the officer described it.
How did the officer describe it?
I can't quote it back to you directly, Your Honor, but
So on page 148 of
Go
the
ahead.
transcript,
Yes, sir.
in the direct testimony, it says, when the window was rolled down with respect to your five senses and the ability to hear, see, smell, and taste, were any of your senses alerted by anything as the windows were rolled down? Yes. What sense? Smell. What did you smell? Marijuana. That's the testimony.
So those were very leading questions, Judge. The officer did not himself say that the odor was emanating from the car, and that is a problem in this case.
Well, those were his answers. Did anybody object to the leading questions?
No, Your Honor, but I think that there was additional evidence for the court to consider.
Well, let's assume for now that he smelled marijuana when the window was rolled down.
Mm-hmm.
Do you still have an argument that that's not probable cause?
I think I understand.
If I was you, I would be arguing Baxter and saying we should follow Baxter and say the smell of marijuana alone is not probable cause. Well, why won't you argue that?
I would love to, Judge.
Okay, go.
Thank you. Again, the officer's reliance in Baxter on binding precedent was objectively reasonable. That's what the court held in that case. And that precedent was based on Owens. So talking about Owens a little bit, in Owens, the second district disapproved of the lower court's holding in State v. Nord, but both of those cases are based on traffic stops. So kind of getting back a little bit to the issue of where we are in this case physically. We are not outside of a closed business. We are not at a traffic stop.
He's in his car about to start it up.
Sure.
Okay.
But he wasn't stopped for any traffic infraction. Again, he's legally parked. Again, I would
Well,
point.
no, I don't know that the record shows that at all. I mean, the record shows he was asked to put it into park twice. The lights were on. Have you watched the body cam video?
Yes, Your Honor, I have.
So it was operational and ready to go. How is this not a stop? He was told to stop. He was told to put it in park.
Well, Judge, I think everyone is agreeing as well that it was a consensual encounter, right? There was no traffic infraction, so how can there be a stop? If there was a stop, then that's certainly the illegal seizure. Why would his car have been stopped if he hadn't done anything?
Well, again, whether he was charged with driving under the influence, I mean, an officer investigating, takes the facts as he finds it, and if they find cocaine and other things in a car, maybe they're not looking at driving under the influence and some of these other things that would be more difficult to prove. But what we do know is we have a defendant behind the wheel of a car that's operational who smells, and an officer smells marijuana, right? That could give rise to the violation of multiple crimes under Florida law.
Potentially, and there's also the obvious potential innocent behavior there, that either someone else in the neighborhood was smoking, which there is record testimony of, which is uncontradicted, which there wasn't a credibility issue with, and then we have the officer who doesn't remember whether the smell was of burnt or raw. I understand that some of these cases have differing opinions on whether or not that even matters. I certainly think it does in a case where the court is considering whether or not there is a driving under the influence concern.
Well, and it should matter to your argument on Baxter too, right? Is there an indistinguishable smell between unburnt and burnt cannabis and hemp? We don't, I think there's nothing in this record that supports the arguments that will be presented to the trial court, and no evidence that's being presented to this court.
I understand, Judge. If I may kind of go back to the conversation about Baxter. So again, where we are, the defendant in Baxter is outside of a closed business, a situation where there's no one else around. That's kind of a specific issue there. And there's a smell of even unburnt marijuana in that case, which is specifically what the officer said. In that situation, an officer may indeed have further reasons to investigate and have concerns of impaired driving. Some of the concurring opinions highlight more facts than the opinion itself provides. Additional facts that were known to the 5th District included that the officer observed Baxter's car pulling into that lot, and that business was closed, and then he didn't leave. The officer asked Baxter some simple question that he answered inconsistently and perhaps even suspiciously. Those two factors, in addition to the smell of marijuana emanating from the vehicle, which was more clear in that record, and I stand on my argument that that's not the case in ours, no one else was around. That does amount to reasonable suspicion. In this case, the distinctions are we are outside of a residential neighborhood complex. We're parked legally in front of the building. The officers saw him earlier, interacted with him 15 minutes prior to this stop, if that's what this is. And he comes out of his apartment building. He walks without any issues. He gets into his car. He responds appropriately to all of the officers' questions. He removes himself when he's asked to be removed. He places his car into park, arguably. So I would argue that there's more affirmative evidence in this case of a lack of criminal activity and of sobriety even. Mr. Florence is not acting in a suspicious way.
Now, you're well into your rebuttal time, just so you know.
I'm sorry, Judge?
You're well into your rebuttal time.
Thank you, Your Honor. I think I'd prefer to just kind of keep rolling here for just a few seconds. We know that Officer Pendak also knew this defendant. This is someone that was known to him. He knew he lived there. This was not a potential burglar. This was not a potential trespasser. And again, there was no traffic infraction. And with that, I would ask to reserve the rest of my time for a rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Opposing counsel, may it please the court. My name is Charlie Lee. I work for the Attorney General's office, and I represent the state in this case. I'd like to state by pointing out the obvious. On one hand, we have Owens, which says that the smell of marijuana, which this state has recognized as a distinct smell, is still probable cause for an arrest, or at least a search. And then Baxter, on the other hand, which the court there, the majority, if we can call it that, said it wasn't reasonable suspicion in that case, but they said that the officers could reasonably rely on Owens because that was the controlling precedent. At that time, it was when Mr. Florence was arrested as well. Owens was only 7 months old, I believe, when Mr. Owens was arrested in October.
So you're basically making a Davis-Hine argument that we need to affirm.
Correct, Your Honor. U.S. v. Davis, that's not my main argument, but that's my safety valve, if you want to call it that.
Go ahead. You go
So
ahead.
you're saying that if we happen to agree with the Baxter court and don't agree with the Owens court, we need to do what they did in Baxter and make a statement and certify a question, but still affirm?
Yes, Your Honor, if you agree with the analysis of the majority, which I disagree with. And the reason I disagree with it is the There are three categories of marijuana. There's hemp, which Baxter talks about, which is, according to the Baxter case, legal in all instances. You can even smoke it in a car, according to the majority in Baxter, footnote 4. There's medical marijuana / low THC cannabis, different than hemp, stronger than hemp. That cannot be smoked in a car.
Or it would be illegal. It's a substance that impairs you.
Correct. So it's, the way I read the statute is medical marijuana is no longer medical marijuana as soon as you start smoking in a car. It's not for medical use at that point. That's
Well,
what
it's just like if your doctor prescribed you Valium or hydrocodone, if you take it and get in your car, you're committing a violation.
correct, Your Honor.
Okay.
Then we have street marijuana, the marijuana that is illegal in all cases, for lack of a better term, I'll call that street marijuana. So in this case, I think Mr. Florence would like the court to believe that the Officer Pandak smelled raw marijuana. That's not clear from the record at all, but
Well, he said he didn't know. Does that matter? And that seems to cut against your case because he couldn't testify that he smelled the smoking marijuana, which would have been certainly probable cause if he was about to operate his vehicle.
certainly that would be better for my case if he said, I smelled burned marijuana.
But he said, I didn't know, so
don't
we have an
recall."
indeterminate thing. Did the state meet its burden?
According to the trial court, it did, and the trial court's order
Well,
is
that's what we're
presumed
here for.
correct. Well, it's presumed correct, and I think I'd like to read between the lines in the trial court's order and say that it found or believed that Officer Pandak smelled burned marijuana. Now, that language is not in the order.
Well, is your underlying argument that marijuana is illegal under federal law?
That's true, Your Honor, as
So
well.
it's irrelevant whether the state of Florida, whether it's through an amendment process or any other way, purports to claim that it's legal. Is that right?
I don't know
Let's
that-
try a hypothetical. Let's say the amendment passes in 2 weeks and marijuana is declared legal in the state of Florida. Can a law enforcement officer still make an arrest upon smelling marijuana?
Your Honor,
Isn't it illegal under federal law?
it is illegal under federal law. I'm
And
not.
can an officer make an arrest of a violation of federal criminal law?
I believe-
Let's say a person's robbing a bank, and for whatever reason, that becomes legal under Florida law. Can a police officer arrest a bank robber because he knows it's a violation of federal criminal law?
If he observes a federal violation, he could, Your Honor.
In fact, under the arrest chapter, a trial judge can issue a warrant for any crime.
Correct, Your Honor.
Doesn't say state or federal. So even assuming marijuana becomes legal, it's illegal in all times, at all times, in all places under federal law, is it not?
Yes, Your Honor, and I would argue
That
that.
might eventually change, but right now, it's always illegal to possess marijuana. Is that not true?
Marijuana, yes, Your Honor, but not.
I don't care if it's medical marijuana or what label the state of Florida puts on it. Is it not true that it is always illegal to possess marijuana under federal law?
That is true, Your Honor.
And I issued a case this year that said the DOC could fire a correctional officer for using marijuana because they couldn't give him a gun to use in his job because they would be violating. federal
Violating
law.
yes, Your Honor.
I mean, maybe the question could be put this way. Can the state of Florida authorize the violation of federal law?
No,
Under the-
Your Honor.
Under the supremacy clause?
No, Your Honor, no. The federal law would trump state law.
So if the officer here smelled marijuana when the window rolled down, he did ask if he had a medical marijuana card, but when asked whether he would still make an arrest if a person had a medical marijuana card, the officer said, perhaps. Perhaps. So the question is the possession, is the smell of marijuana alone probable cause to make an arrest, irregardless of what Florida law might provide?
Yes, Your Honor, and I'd like to take that argument and kind of change mine a bit. And
No, I got a question based on something Judge Thomas, when did go back to what I asked Ms. Diaz-Wade, when did the seizure occur?
The seizure?
Because I think he asked about the marijuana card after he commanded him to get out of the car.
he did.
And so he was seized at that time.
I would say he was under a Terry stop at that time. He said, get out of the car, go to the front of the car by the other officer. why do you have, and then he asked Mr. Florence, this is Officer Pandak, do you have a marijuana card on you? He says.
But he was in custody.
He was detained.
He was detained,
You would need at least reasonable
and he wasn't
suspicion.
Mirandized.
Not at that time, but
And
that's not an issue.
He was in custody, he responded to a question.
Correct, Your Honor.
Okay.
And he said, do you have a marijuana card on you? He said, no. Pandak says, why do you smell like that, man? And then Pandak starts to.
Let me ask this question. What if he had a marijuana card, medical marijuana card? Is it not still a violation of federal criminal law?
It's a violation of criminal law.
Can an officer, a law enforcement officer in the state of Florida, I'm asking, can a law enforcement officer in the state of Florida arrest a person that he knows is violating federal criminal law?
I would think so. I
Like
don't know the
bank robbery.
I don't know the parameters of the authority of, state officers arresting for federal offenses,
Well,
like you
it's-
said.
Well, let's
So
take
look at
state
the-
law. If, he's behind a car that's running, has to be asked twice to put it in park. If he had a medical marijuana card, is that still going to be a problem under state law?
That's a problem, especially if the marijuana is burning. Now,
But we don't know if it was.
that's correct.
Officer
But-
Pandak didn't
and-
remember.
And we don't know, again, it doesn't matter if the state ultimately charged him or didn't charge him with driving under the influence or being behind the wheel of an operable vehicle. I'd like to shift a little bit to what was before the trial court. Was there any testimony or evidence that would have allowed the trial court to find that the smell of legal hemp is legal under federal and state law, is indistinguishable from the odor of marijuana?
No evidence, and I don't know of any court that's, this court actually in Hatcher did say in Judge Bilbrey's concurrence, cited in IFAS, the University of Florida Agricultural Service, if I remember correctly, a study they did that says the smell is indistinguishable, but I don't know that that's been part of any majority decision.
Right, and let's just take that concurrence aside. I mean, it's certainly not binding on this panel, but let's talk what trial courts do when they're looking at a suppression motion. Are they supposed to look at evidence, or should they be looking at law review articles at that point about the potency of the smell of hemp and marijuana?
Evidence, Your Honor. They should bring in there should be some type of expert. It would be nice to have that, or some type of testimony as to whether hemp and marijuana smell exactly the same, even assuming that they do. In that case, and I think Judge Thomas pointed out, since marijuana is illegal in all instances, whether it's medical or not, so now we're down to two categories, hemp or marijuana, and Officer Pandak would have smelled one or the other. My argument is he doesn't have to eliminate every possibility of innocence to have reasonable suspicion or probable cause.
And that was going to be my next question. I mean, the United States Supreme Court in Glover says exactly that, right? They look at all, you look at all of the circumstances, and is it likely that they're smoking hemp versus marijuana? Particularly because the defense entered its own evidence that everybody else was smoking marijuana. So is it likely that in this apartment complex where the appellant is arguing they were close enough that it could have been other people smoking it, that it was actually hemp that this defendant was smoking? I mean, again, looking at all of those circumstances and what is probable, isn't that what Glover compels the lower courts to do, including this one?
Correct, Your Honor. And I'd agree that Mr. Florence really hurt himself by bringing in testimony that this is a place where people smoke marijuana all the time. Like in Glover with somebody driving down the road with that has an expired license and the tag matches up with that expired license, 9 times out of 10, maybe less than that, maybe 4 times out of 10, but that's going to be the driver, the person with a suspended license is going to be driving that vehicle. There's certain common sense analyses that courts can make from everyday life. And that's one of them. The owner of a vehicle is going to be driving the vehicle most of the time. If you're in a place where people are smoking marijuana all the time, you have a guy in a car, it just, the circumstances, and Your Honors have seen the video, the circumstances there coupled with the fact that Florence's, I think it was a significant other, said that people smoke marijuana all the time. They even tried to pin it on another guy that was smoking marijuana out there. That altogether, and probable cause, as Your Honors know, is a totality of the circumstances analysis. In this case, I think this court should affirm, because the totality of the circumstances gave those officers probable cause to search Mr. Florence, and they, lo and behold, they did find marijuana. Based on that argument, Your Honors, I would ask this court to affirm and find that there was probable cause to search Mr. Florence for the marijuana. I would like to point out something. I don't know that it came out in the briefing, but it's in the record that during this transaction he actually ran. And it's not clear, but from the arrest report, it appears that they may have found most of his charges would have stemmed from that running and not from the actual first contact, the seizure of the MDMA, the resisting without violence. This was resolved with a plea, and the reason I'm bringing that up is it muddies the record a bit as to whether this is even within the court's jurisdiction, because I did argue that it's possible that this issue is not dispositive of most of his charges, his resisting without violence, possession of MDMA. So I'd ask this court to affirm, either based on lack of jurisdiction or find that the court did have, that there was probable cause to search Mr. Florence, or in the alternative, follow the precedent from Baxter, finding that the officers reasonably relied on Owens. That concludes my argument. Thank you, Your Honors.
Thank you, Your Honors. Going back to our conversation earlier, I would like to highlight that the trial court's order does indicate an understanding of the difference between marijuana and hemp. In this, and also just pointing to a little bit of the discussion in Baxter, hemp has actually been excluded from the federal definition of marijuana. Florida has a hemp state program that we need to consider as well. Going back to the conversation with Judge Rowe, the officers did tell Mr. Florence to park his car. And they did so without suspicion of anything, without there being a concern for safety, and we think that this court should follow Baxter. Additionally, there was no evidence of burnt marijuana in this case, as we've discussed. There was evidence of sobriety. And with that, I would rest.
Thank you. Thank you both for your arguments. The court is in recess.
Thank you, Your Honor.
All rise.